If you even suspect the defense may try to imply your client is faking or exaggerating, you must put on your armor, pick up your sword, and charge into battle on this issue. They have thrown down the gauntlet. Welcome back to Law Ventures Book Club, where I share insights on the books that I've read and found helpful with the Law Venture community. And today's book is another Rick Friedman book, Polarizing the Case. And this book makes me so angry, but for all the right reasons. It makes me angry that I didn't read this book as a plaintiff's lawyer earlier and sooner. I feel like I have been leaving money on the table by not implementing the strategies in this book.
Stop it. Get some help.
By implementing Rick's strategies, I've noticed that I'm now putting more pressure on the insurance company and increased pressure on the insurance defense lawyer. Increased pressure has resulted in increased offers. That's a good thing. That's a really good thing. And so I've had this book next to me nonstop. And so we're going to talk about what this book is all about. We're going to talk about the concepts and what this book provides. So if you're a plaintiff's lawyer looking to better bulletproof your client's cases and hopefully be able to get those increased offers, keep watching. In order to really set the scene for this book, we need to acknowledge two problems that every plaintiff lawyer is going to need to address with any type of personal injury case. Problem number one is that the defense is going to imply, insinuate, or flat out accuse your plaintiff of malingering. In other words, the defense, to some degree, is going to call your plaintiff a liar, an exaggerator, and a cheat who's trying to hit the litigation lottery. Problem number two is that baseless charges of malingering can take root and blossom in the jury box. You may be asking yourself, if the charge that my client is a fraud, liar, and cheat is baseless, and that charge is being made by the defense, then why would a jury latch on to a baseless claim that's being made? Well, Rick answers this question in a couple ways that I'll kind of condense for you here. He says in scenario number one, maybe the jury just has a natural skepticism with plaintiff lawyers and plaintiffs. Scenario number two, it's just sometimes easier for a jury to have the story that plaintiff is over-exaggerating and lying compared to the alternative. And that alternative is believing plaintiff's story of this injury occurred, and now because of the injury, here are all the ripple effects to the plaintiff's life and all the pain, the suffering, loss of enjoyment of life, inconvenience, all those non-economic damages, and a lot of information that you're going to ask a jury to have to internalize and ultimately use to determine the value of the damages. It's a lot easier to say plaintiff gets nothing because plaintiff is over-exaggerating and doesn't have credibility compared to, okay, let's take all this information, all these facts, and determine what the damages are at the end of the day. So Rick's point on this scenario number two is sometimes that easy route is what the default route is with the jury. And defense lawyers, they know this. Rick makes a great point. As a plaintiff's lawyer, the plaintiff has the burden of proof. So you're having to put on the case. You have to prove by preponderance of the evidence that your client is more likely right than wrong. If there is a tie to where the jury says, yeah, I don't know, maybe the defense is 50% correct here and the plaintiff is 50% correct here. Tie goes to the defense. Your client isn't getting anything. Your client loses in that situation. So we are asking, as the plaintiff, we are asking the jury to be motivated enough and energized enough to do the right thing. That requires more energy, more effort. And so we need to put the case in a certain light, in a certain perspective, that it does motivate the jury. This is where polarizing the case comes in, because what you're ultimately going to do is simplify the case for the jury so that they have two options. They're at a fork in the road and they have to choose which story is going to motivate them to reach which particular decision. What I'm about to say is not only the heart of Rick's book, but it's the true battleground of cases that plaintiff lawyers are taking to trial. What we need to win first and foremost is the battleground involving the plaintiff's character and credibility. If you can win this battleground, then everything else, whether it's medical bills or medical treatment, begins to fall in place. If you've watched my interview with Rick, which is probably sliding above, but I'll put a link to it in the description below, you know that Rick just naturally has a very gentle demeanor, but Rick does not mess around when it comes to defense lawyers trying to use the malingering defense. So to set the tone, I'm going to read a portion out of the book. Here is the lesson. If you even suspect the defense may try to imply your client is faking or exaggerating, you must put on your armor, pick up your sword, and charge into battle on this issue. They have thrown down the gauntlet. The rest of this book will teach you how to recognize it, pick it up, and then stuff it down their throats. Whew, that gives me the chills. Here's the warning, and these are my warning hands right now. Rick repeatedly addresses throughout the book the fact that most experienced defense lawyers are not going to come out and outright point at your client and say that your client is a liar, a cheat, a fraud, an over-exaggerator. Instead, what they're most likely going to do is take a much more subtle approach to plant the seed of doubt in the jury's mind in the hopes that the jury doubts your client's credibility. The defense lawyer may do something as small as point out an inconsistency in your client's medical records or a slight inconsistency in your client's testimony, in the hopes that highlighting that slight inconsistency, again, may plant the seed of doubt and, in a roundabout way, attack your client's credibility. And if your client loses the battleground of credibility, then your client cannot win the case. At this point, it is crucial for you to understand that there is no half pregnant. There is no spectrum of credibility with your client. Either your client is credible or is not credible. It's binary. So even if a defense lawyer were to subtly accuse your client of having an inconsistency and not being credible on one small issue, well, keep in mind from the jury's perspective, your client not being credible on one small issue may also lead to them thinking that your client isn't credible on all the remaining issues as well. Because if you don't have credibility on one aspect, how can you have credibility on everything else? So again, it's binary. We need to prove our client's credibility, and we need to attack the defense for making accusations that are false and baseless against our clients. The solution here, because this is a binary issue, is doing away with the spectrum and polarizing the case to where you have two extremes that are going head to head. So in this video, we're going to talk about how to achieve just that. With all that said, that takes us to the end result at this point that I'm going to tease, because what we're going to do is tease the end result, but reverse engineer it at this stage in order to figure out the steps in order to get to that result. So the result that we're trying to ultimately achieve is presenting the jury with two competing stories. We want to put them at the fork in the road and say, here's plaintiff's clear story, and here's the defense's clear story. Choose one, but we want to make it as clear as possible. And the best way to do that is to polarize the case. So like I said, we're going to tease that for now and then reverse engineer by going through the steps that Rick outlines in the book in order to achieve the goal of polarizing the case. Step one, force the defense to take a position. Is the plaintiff malingering or not? It's a yes or no question. It's binary. Remember, there is no half pregnant. So what we want to do is pin down the defense on this position well before trial. In fact, Rick has discovery request examples inside the book that I've started using on all the discovery requests that I initially send out. And I have to say, it makes insurance companies and insurance defense lawyers so uncomfortable when the first wave of discovery that goes out makes them take a position. Step 2, force the defense witnesses to take a position. Again, we want to make this binary. Either plaintiff has been injured and has legitimate symptoms caused by those injuries, or plaintiff is completely faking. We want to be able to pin the defense witnesses down on this very issue. Keep in mind, whenever you are trying to pin down a defense witness, especially during a live examination, for example, like a deposition, having them pinned down to where they're calling your client a liar, a cheat, a fraud, and a malingerer is going to make them very uncomfortable. They rather make subtle jabs and accusations instead of outright making the bold assertion that's going to be clear for the jury to hear. There's always comfort in being subtle compared to the discomfort of being open with their conclusions and their thoughts. And so you'll oftentimes find the defense witness, for example, like a IME expert that the defense lawyer hired, start to circle the topic and maybe try and flounder a little bit in order to avoid being pinned down. But the more you can expose a defense witness not being straight with clear and concise questioning, that defense witness is going to start cutting against their credibility. And if they don't have credibility, it goes both ways with the jury. If you're not being credible on a simple topic like what position are you taking when it comes to malingering, then how can you have credibility for all the other topics that you're testifying about? We want to put the not only defense but also defense witnesses in this state of stress because, again, they're going to be very uncomfortable with having to point fingers at someone, and they'd rather hide behind subtleties. If you want to see this in action, then definitely check out chapter 9 of Rick's book, to where it covers deposing an IME doctor, and he just has questions after questions after questions that he ends up asking or uses as a framework in order to pin down the IME doctor. And then along those lines, he also has real life testimony in chapter 27, where you can see his trial examination of an IME doctor, and he beats up that IME doctor pretty good using the strategies in this book. So again, check out the book in order to get the concrete examples, in order to really understand the concepts that we're talking about in this video. I'll provide a link to the book down in the description below. Step 3, don't let the defense or their witnesses retract from their position. So here is going to be the real life practical effect of trying to polarize the case. It is going to make the defense and the defense witnesses very uncomfortable. They don't want to make that clear distinction that they are making accusations against your client. Rick is very clear on this. Don't give an inch.
Come and get them!
Make sure that you're polarizing the case. Don't let them make things a little bit murkier by coming back and starting to rely on subtle jabs, on implications of inconsistencies. No, make them take the position all the way at the end of the spectrum that they think your client is a liar, a cheat, and a fraud. Here's an example from my own experience. In step 1 of this video, I mentioned how, based off of Rick's books and the templates provided in Rick's book here, I have started sending out discovery requests, and in those initial discovery requests, I start hitting the malingering topics pretty hard in order to polarize the case as quickly as possible. Let's use the interrogatories as an example. With interrogatories, I ask for a list of evidence relating to plaintiff malingering or over-exaggerating symptoms and or injuries. That's kind of like the boiled down version of it. What I've noticed is that the routine responses from all the defense attorneys, no matter the law firm, no matter like the differences in the case, they end up responding with an objection saying that this request is premature because discovery is ongoing and that they'll answer the interrogatory later once discovery is over. But that's not how interrogatories work. It's based on your knowledge at the time that you're filling out the interrogatory. You can't just punt the answer and say, I need more information in order to answer it. If your answer today is there is no evidence to support malingering or that my client is exaggerating, then your answer today is none. If you want to supplement down the road because some piece of evidence does pop up, which is unlikely, then feel free to supplement at that point in time. No issue there. But if as of today there is nothing, then the answer is nothing. And so what I've noticed is defense lawyers, they want to rely on that objection, hope I don't fight it, hope I try and take the path of least resistance. I respond and tell them, look, your answers are deficient. Attached is my deficiency letter explaining exactly what I just said to y'all in this video. And I need an answer within however much time I give them. If they don't provide an answer at that point in time, then I'm teeing up the matter for a motion to compel. The last motion to compel I had, the writing was on the wall to where I think it was a 9 a.m. hearing in order to duke it out. 8 a.m., guess what, guys? I ended up getting the interrogatory response that said none right before the hearing. And so they being the defense, is going to be resistant because it's going to be uncomfortable polarizing the case. But I took Rick's advice to heart. Don't give them an inch, and as a result, keep building your client's case. Step 4, destroy that position.
Kaboom!
Yes, Rico. Kaboom.
So Rick's book is focused on polarizing the case in situations where the defense does take the position that your client is malingering. I'm going to backburner that just for a quick second to address the situation from the previous step with that example where I get the written response saying that there is no evidence suggesting or related to my client malingering or my client over-exaggerating symptoms and injuries. If I get that no, and there is, I guess, a position that the defense takes at trial, even subtly suggesting my client is malingering, then I'm impeaching on that matter and I'm going to attack the credibility of the defense in that situation. Or if they don't challenge at trial and stick with the fact that they have no evidence to support that my client was malingering or was being a cheat, fraud, and over-exaggerator, then I'm going to take that and run with it too, because my client's non-economic damages and injuries are basically uncontested. It really is just a question of what the damage value is at that point in time. But if the answer again is no, then I've essentially won that battleground on credibility. And that's a big win because everything else starts lining up. Now, let's get to the heart of the book to where it's destroying the position of the malingering defense, the malingering accusation. In that situation, Rick wants you to be heavy-handed and basically wants you to nuke the other side. Rick said in my interview with him, and he teased this, that the lay witnesses to a case involving personal injury, those lay witnesses for the plaintiff can be a secret weapon. And he teased it. I didn't necessarily know what he meant exactly, and he told me to read the book, which is why I read the book. And now I wholeheartedly agree, because if you have a defense saying that your client is over-exaggerating their symptoms and their injuries, but you have an army of doctors, friends, and family that all can attest to your client's story, then which one is more credible? On one hand, you have a defense who's making a bold accusation, and on the other hand, you have an army of people who are testifying under oath to your client's credibility based on their testimony tracking with your client's story. That is the offense. That's the destroying that Rick is talking about, to where even though they're going to take that position, you need to come in with droves of people and ultimately blow that out of the water, because that takes us to the next step. Step 5, repeatedly draw attention to how the case has been and is being defended. Rick makes it super clear by the defense and the defense attorney challenging your client's credibility, then they're effectively putting their own credibility on the line and making that an issue at trial. So let's factor in step 4 when considering step 5 for perspective. We have witnesses who are testifying to our client's story in order to build our client's credibility up so we can win that battleground. Because credibility is now at issue, that cuts both ways in the eyes of the jury, because the jury then looks at the defense and is thinking, what kind of person runs a red light, injures another person, and then falsely accuses that other person of being a liar, a cheat, and a fraud? Who does that? Let's talk about the result. And this is what I teased earlier about reverse engineering. We've followed these 5 steps to get to this point. There are now 2 competing stories. You may see where this is going, but let's make it super clear. Story number 1 is that we have a plaintiff who's a liar, a cheat, and a fraud, and has fooled the plaintiff's treating doctors, friends, and family that all came to testify in support of the plaintiff. Or alternatively, along the lines of story number 1, we have a plaintiff that is a liar, a cheat, and a fraud, and the treating doctor, the plaintiff's friends, and family are all liars, cheats, and frauds as well, and they're all in on some massive conspiracy. If that's the case, then the plaintiff should be ashamed and should go home with absolutely nothing. On the other hand, the competing story, the clear picture that we're trying to paint in order to polarize the case, goes a little bit something like this, which I'm going to read because Rick's words here are very powerful. Plaintiff has followed the rules all her life. She is an honest person. She was injured through no fault of her own due to the defendant's carelessness. Not only will the defendant not take responsibility for his carelessness and pay for what he broke, he is now calling plaintiff a liar, a cheat, and a fraud. He's doing this because he has no liability defense and no damages defense. He and his attorney also have no sense of decency. They are willing to make these awful allegations to get out of paying what they owe. They should be ashamed. This is the goal. This is what we've been talking about in this video. You want to polarize the case to have these 2 clear and competing stories. Either your client is a liar, cheat, and a fraud and should go home empty-handed, or the defendant is the one whose credibility should be questioned and should, as a result, not be believed. It's all about polarizing the case. The strategies are in this book. I can only talk about so much in a video like this, but if you want to see the concrete implementation of what we've talked about, the methodology is in here. Be sure to check it out. I'll put a link in the description down below. But before you go, we need to leave on Rick's words, not mine. And here's what he has to say. It takes courage to polarize a case. It feels risky. You have to leave your safe castle of intellectual arguments and technical jargon and seek out the dragon. You would prefer not to enter his cave or to pretend he doesn't exist, but those are not realistic options. You have to enter his cave and expose the dragon to the light of day. If you muster the nerve to do this, you will discover the dragon is almost always a pale, sickly creature that cannot survive in the sunlight. You may even feel some sympathy as he shrivels and dies in the fresh, open air. Then again, maybe not.